briefly talk about the work that Housing Network Rhode Island does, as well as Homes RI. So the Housing Network is kind of the backbone in terms of Homes RI. Me, Nicole, Katie, a couple of other of our staff members, we work here every day to make sure that not only are we connecting people with direct services, but we're advocating for increased number of affordable housing throughout the entire state. And a part of that is making sure that we educate the public, educate advocates as to the best possible route for them to be able to achieve what we all want, right? Which is making sure that everyone has a place to live that's affordable to them. And so, like I said briefly, we're a coalition of organizations, so it's not just us, we're a network. Housing Network of Rhode Island, we have 15 members of different affordable housing developers that focus on making sure that folks are able to have a place to stay in collaboration with us. And as I mentioned before, Homes RI is kind of that overview to the work that we're doing, as we have over 80, it says 80 plus, but we have around 86 members in terms of folks that are supporting our work that have pledged to the same thing that we're fighting for, which is increased number of affordable housing. And so that brings us to today, where we're joined by our incredible guest here by Rhode Island Legal Services to kind of talk a little bit about more info around the roles and responsibilities of tenants and landlords, and making sure that folks who have any questions can have them answered, so that when we're up at the State House or when we're just going through our day-to-day life, that we all have the proper information to be able to advocate for ourselves and advocate for our communities. And so I'm not sure who wants to be introduced first, so I'll just kind of introduce you as a team, and then you guys can start intros for yourself. Sounds good?
Sounds good. So, hey everybody, I'm Steve Flores. I'm the Director of Litigation and the Director of the Housing Law Center.
I'm David Leveley. I've been a housing attorney for about 5 years at Legal Services.
And I'm Katie Barrington. I'm the Housing Navigator with Legal Services.
So, so it's a small group, which is, I think, good in a lot of ways. And I guess if you don't mind, so I can get a sense of where we might want to take this. Where are you from? Who do you work for, and
Sure.
that kind of thing?
So my name is Faith. I work at Sojourner House.
Oh, great.
I am the youth diversion and navigation advocate. So I primarily work with young people under 25, but I'm also, we do a housing clinic every Thursday. And
Yes.
so I'm working with that whole entire population, not just
Yeah.
youth, to connect them with housing and, resources, and send them to our legal services.
Yeah.
So I'm happy to be here to learn some more about how that process works once maybe that referral gets through. I don't really know what happens after that. So
Awesome.
yeah, I'm
That's
curious about
helpful.
that. Yeah.
We can cover that.
I'm Eva. I work with the Housing Network.
Oh, great.
But I also work with the housing counselors. So we do get a lot of calls from people asking for housing assistance. And Katie, I remember you from Rent Relief.
Yes,
From the Rent Relief.
back in the day.
Yeah.
Hi, I'm Allie. I work at One Neighborhood Builders, and I'm interested in making sure I'm not missing anything.
Awesome. And then,
I'm Daniela. I'm Congressman Gabe Amos Lewis caseworker serving Rhode Island's 1st District.
excellent. So, maybe I will at least hope this way. I was hoping that what we could do for you today is, number one, make sure you came away with what I thought were a couple of kind of new, useful points that may not have worked their way out there yet, because there have been some changes in the law that I think it's helpful to know about. But also give kind of an overview of the eviction process, the types of cases there are, and that sort of thing. And then I know most of you know how to get to us, but to give you a sense of kind of our process, and like you said, what happens after the referral is made.
Yeah.
So just real quick, and then I'll kind of set the stage, and then and then hand it off to Dave and Katie. But Stu, has anybody in here in the last 3 years paid a rental application fee when they've rented an apartment or tried to rent an apartment? So, yeah, anybody else? No? Okay, so good news, you can't do that anymore. And that's,
Just missed it.
yeah. So that's, as of January 1, 2024. I'm just curious, how much was the fee?
I believe it was like $25 or $30.
Okay,
Yeah.
and what'd they do for that? What'd they say they did for that fee?
That I was allowed to apply.
Yeah, it's crazy,
Yeah.
right? And so 25, 30, I've heard of much worse.
Yeah.
I don't wanna say that you got off easy, but you kinda got
Sure.
off easy.
Sure.
But yeah, so now, as of January 1, 2024, landlords, property managers can no longer charge rental application fees. There's a little nuance there that you should know about. They can charge you for like a BCI, criminal background report. They can charge you for a credit report. But if you can give them one, a BCI or a credit report, that's less than 90 days old, they can't charge you for that. And then if you can't, they can only charge you actually what it costs. So it's not like the old days where they could say, and this is what we hear about, $100 to apply. You know what I mean? So, so that is, I think, an important thing to keep in the back of your head, because it was getting to the point for us that we would get lots of calls about rental application fees, and there were very few limitations on what could be done there. But obviously, that was a way that landlords, property managers could weed people out in the application process by just charging a fee that lots of people couldn't really afford. So that's one, I think, small but important change that should help a lot of people. The other thing that I just want to put on your radar before maybe Dave starts talking about the eviction process in general is you have probably heard about the new eviction ceiling law. So it used to be, prior to January 1, 2024, if you were evicted, or even if you had an eviction case filed against you that you ultimately won, right? Landlords could look on the public court portal and see, oh, this person had a case against them, 2 cases against them, 5 cases, whatever. You can see all that. You can still see all that. There was never anything you could do about that. And now there's at least a little something you can do about that. So there's a new law that went effective January 1, 2024 that allows basically tenants, but it can be the tenant or the landlord, to make a motion once every 5 years to seal an eviction case if certain criteria are met. So, it's only once every 5 years. So if you have more than one, you'd want to pick and choose which one you think you want to seal. And when I say seal, I basically mean have taken off the court portal so nobody can see it. So that's good news. Here's the bad news. The bad news is that the law, because it went effective January 1, 2024, is being interpreted to only apply to eviction cases that came after January 1st, 2024. So if you're trying to seal a 2023 case, unfortunately, you can't do it unless and until that law gets amended. But if something happens this year and you meet the requirements of the law, in all likelihood, you'd be able to get it sealed. So those are a couple of updates that I just wanted to start with because I think they're updates that people need to know about. Dave, why don't you start,
Yeah.
give an overview of evictions?
Yeah. So I'm a housing law attorney, means I spend most of my time, at least a part of every day, in court, in district court, where every eviction case in Rhode Island is filed. And legal services, most of the time, gets involved on behalf of a tenant when a case is filed in court. That's the trigger that kind of is the catalyst for our involvement. There are some instances where we're able to be more proactive in subsidized housing situations before a lawsuit. But most of the time it's because a complaint's been filed by a landlord. There are generally two types of eviction lawsuits that a tenant might come to you seeking assistance with. One has to do with money, and the other has to do with possession of the unit. Those are the two remedies that a landlord can seek when they want to file a lawsuit. And generally, they kind of choose a lane at the beginning. A case about money can be resolved by the tenant paying money. A case about possession is a little more complicated. What we tend to see, Kate and I, especially in the time we spend in court, is that there are a lot of problems that exist between landlords and tenants. They exist for a long time, they take a lot of permutations, but because of the court process, they can only manifest themselves in court as a non-pay eviction or a termination eviction. So sometimes we do a little bit of forensic work to try and figure out what's really going on in a case and how it can be resolved, even though the landlord said, hey, you owe me money, or hey, you have to move because I'm terminating your tenancy. One of the problems we see, as long as I've been doing this, the vast majority of tenants that we deal with do not have the protection of a valid lease. They live in what's called a month-to-month tenancy. It may be that they had a lease when they first moved in, right, for the first year or the first 6 months or whatever that time period is. But then once the lease expires and the time period of the contract comes and goes, the landlord has the right not to renew that lease. And the tenant exists kind of in a month-to-month renewal of the expired lease. The idea is the lease contract renews every month when the tenant pays the rent. It expires at the end of every month when the rent runs out, and then it gets renewed again the following month. Under Rhode Island law, right now, tenants can be evicted from a month-to-month tenancy with 30 days written notice. Not a lot of time. And when we're dealing with I think a market where supply is as scarce as it is right now, that puts a lot of our tenants, in a very stressful situation. So some of the work that we do is trying to help tenants who find themselves at the short end of a month-to-month tenancy termination. I should say that in either case, like the non-pay case or the termination case, the thing that has to exist before a lawsuit can be filed is a delinquency notice to the tenant. So it may be that a tenant coming to you for assistance, they might show you court paperwork, but they'll probably show you a notice or refer to a notice. Hey, my landlord sent me a notice, right?
Can I add just a couple of things?
Yeah.
So think of it this way, right? The law says to the landlord, you get the benefit of a very expedited, sped up procedure, but you have to do one thing right in order to get the benefit of that procedure. And that is you have to provide a written notice that complies with the statute. So if it's a non-pay, there's a certain form for a non-pay notice and the landlord has to meet the statutory requirements. If it's a breach of the lease notice, the landlord has to meet those statutory requirements. Same thing with the termination. Different requirements. And the thing is with the terminations that we see so many of, the important thing to remember there, and what leaves a lot of tenants scratching their heads, is a tenant doesn't have to do anything wrong in order to get terminated. You can think of that as a no-fault termination, and I've explained that before as, think of that as the, like, it's not you, it's me case, right? It's the landlord saying, you didn't do anything wrong, I just don't want you there.
They don't have to give a reason in a lot of cases.
Yeah.
The reason why it's important to figure out what the notice says and when it was sent and what it contains is because there's a lot of information that's valuable to us on that document, but it also contains the seeds of a legal defense for the tenant in the event that a landlord has made some kind of mistake or their attorney's made some kind of mistake. There's a famous quote that floats around I've seen a few times that says, every happy family looks the same, but every unhappy family is unhappy in their own way. Have you seen that? The notices work like that, because a valid notice that's in conformity with the state statute will look the same. They all look the same. There's one way to do it. But the amount of variety that goes into what a faulty notice looks like, the amount of ways that a landlord could kind of put their legal case in jeopardy, like there are a lot of permutations of that. So any tenant that you're trying to assist and you're thinking about directing them to us or another organization, it's always good to ask them, did your landlord send you a notice? Can you access it? And then you can, help them discern what it says or what's going on. If a notice is about delinquent payment, it's important to know that off the jump, because as Steve said, that's its own kind of case. The notice will have specific information about that, but that one of the great things that will tell the tenant is what they owe and what they can do to cure, which would make the case go away. It's possible that a non-pay case can go away with the payment of the money. When a tenant gets a non-pay notice, the statute gives them 5 days from the date of the notice to pay. And that's a 5-day window where, like, a lawsuit can't happen in those 5 days, or shouldn't happen, if the tenant pays the money. Now, the cases we tend to see are cases where that 5-day window may have come and gone, and now the tenant's faced with a court date. Still important to get as much information as you can from the tenant about when they have court, what communication they've had with their landlord since they got the notice. Sometimes the answer is none, but sometimes the answer is, oh, here's my phone, here's everything we've been talking about. Here's the deal they offered me, or here's what they're willing to do. All that stuff's really, really useful for us to know and for us to discuss with the tenant when they get to court, because I'd say a vast majority of cases that come to court get settled at court without being tried in front of a judge. That's something, I think, frankly, that landlords rely on. And they rely on the potential imbalance at court of a landlord being there, knowing about this case for 3 weeks in advance, having paid a lawyer to help them file the paperwork, get all the information, and then the tenant shows up on the day of the hearing, scared, nervous, alone, unrepresented, and they can get a good deal that way.
Can I chime in on a couple
Please.
of things? So yeah, when it comes to what are the kinds of pieces of information that you want to kind of have floating around in your head if you're helping someone, right? So one good thing to know is, have you gotten court papers yet, or have you just gotten a notice?
Mm-hmm.
So has there been a case filed against you, or has your landlord just sent you a notice saying pay me, or you got 30 days, or you got to do this, you got to stop doing X, Y, and Z, or I'm going to file a case against you. So is it post-case filing or pre-case filing? What Dave is talking about, the notice requirements, the 30 days, the 5 days to pay, those are all requirements that apply when the landlord-tenant relationship is a private one. What I mean by that is there's no subsidy involved. So no Section 8, no public housing, no subsidy. And that's important because when there is a subsidy involved, tenants have greater rights, greater and different rights. So getting back to the informational piece, if you're talking to someone and they need help, you might ask, do you have a subsidy? People won't always know exactly what kind of subsidy it is. Sometimes they don't even know for sure if they have a subsidy, but usually you can ask questions and kind of tease out whether there's a subsidy or not. For example, if somebody's rent is $100, you can be pretty sure they have a subsidy, right? If somebody has to recertify their income every year, they have a subsidy. They may not know what it is, and that's okay. But those kinds of things will signal to you that, hey, this is someone who may have even more rights than somebody who's in a pure private landlord-tenant relationship. And the last thing that I would say is, as you meet with people who may need our help, the one thing I always say is the sooner they can come to us, the better. One thing we've been able to do, we started this, I think, in September 2021. It was a pilot program originally with the City of Providence that we've now been able to expand. We do have a help desk in every courthouse where evictions are heard across the state. So what's the help desk? It's, we have always been dealing with a problem that has always really bothered me, and that is more than 90% of the time, landlords come to court with counsel. And historically anyway, more than 90% of the time, tenants come to court without counsel. So Dave mentioned the power imbalance, the lopsided dynamic. It's true. And so what we've tried to do is bring that lopsided power dynamic a little bit closer to harmony. And so one of the things that we've tried to do with the help desk is we have attorneys embedded in the hallway right outside of the courtroom. And they are basically an unrepresented tenant's last best chance at getting some help. Because even though we've been around for 54 years, even though we do things like this all the time, for some reason, people don't come to us as early as I'd like them to come. So as you talk to people, the sooner you can send them to us, the better.
It's the same. I don't want to psychoanalyze anybody. The reason I think people don't come to us as often as we would like, it's the same reason I don't go to the dentist as often as I need to. Like when something's stressful, when something's unpleasant, the human reaction is to not confront it right away. And I think for a lot of our clients, this is a very, very stressful situation. You know, Steve and I have both tried to impart the idea that the sooner people come to us, the better. And the ideal situation is someone gets a notice, they come to you right away, and you come to us right away. I think what Kate can speak to is that doesn't always happen like that. There are a lot of instances where people come to us after they've already been to court, after they've already had a judge enter judgment against them, or they've signed a deal that they regret, and now they have very tight deadlines or financial obligations, move-out obligations. Part of the great benefit of what Kate can provide our clients is extra legal support and coordination and focus in a way, in terms of what they have to do, and what to think about.
I had a really cool poem that I had on my desk and I forgot to bring it. I was trying to pull it up on my phone. I don't know if you've heard of it. It's along the lines of, there are these people that keep drowning down the river, and the river keeps flooding and flooding and flooding, and people are just giving them rafts and life jackets, and instead of going to the top of the river to see who's flooding the river. You know what I mean? You're just trying to get them to stop what's going on. It's really cool if I had the poem, but I don't know. It's not that.
It sounds amazing.
It sounds cool, but I'm that person that would go up to the river and say, "Why are you drowning all these people?"
Yeah.
So
Yeah.
my job is to go. You know, why are you here? I let them know right off the bat. I'm your number one advocate. I am gonna stand by you until you're housed and good to go, and I'm still gonna be there if something happens in the end. And they still reach out. Like I was saying, about 85 people on my caseload that I'm following. Not like every day, but we've got from September, since I started really tracking, to now, some I contact every day, some I contact every other month, sometimes or they reach out to me, so they know, you know what, I'm behind next month, or I know I'm gonna be behind, and we figure out why. A lot of times when they come to court, our clients don't have, documentation that they either paid or didn't pay or didn't follow something, so I make sure that you're documenting everything you do. Get every police report you can, get every report from the property manager if you can videotape. I mean, not just paper right, but some type of trail that you can have. So they hear paper trail out of me all the time. So that's another thing, just teaching them.
Yeah, so to put the pieces together, Dave and I as attorneys, we can help with the legal problem, right? We can hopefully make the case go away, hopefully help you reach a settlement that you can live with. But the reason why Katie's work is so important is the legal problem exists for a reason, right? And as lawyers, we don't necessarily get to the reason. So Katie is such an important part of the team because her focus is on the root cause of the housing instability. So she'll work with the clients while we handle the case to figure out what the source of housing instability is and try and address it. Because unless you address that root cause, right? Dave may be able to work out a deal on case number 1, but if that root cause still exists, case number 2 is probably not far away.
You don't want to keep rolling the dice with me over and over again if you can have Katie help you too.
Yeah. Like they know when I ever see them again, and I want to see them again. I want to keep seeing them just to see them,
Yeah, but it's, I don't need to tell you, it's hard because I think the clients that we're trying to help have a constellation of challenges, and when they come to us, housing happens to be their most acute challenge, right? But that doesn't mean helping them with their housing problem can make everything else go away, and then those other things rear their heads and they're back in a housing crisis again. It's hard. I'm sure I'm not telling you anything you don't know. We have questions?
I was going to say, why don't we pause and
hanging?
see if people have any questions for us?
Well, I know I've referred people to the clinics. I'm like, I know they have a clinic on Thursday, and I know like the criteria for your program, and I think that's, I wish there was more programs like that, because you're right on the spot, and they can ask all the questions, and they're not waiting for a call back. I mean, I think I would love to see more programs that you're over in. Are you on Pearl Street on Thursday, or?
It's actually on our drop-in center on Westminster.
Okay.
It used to be on Pearl Street.
Yep.
but that's where we are
Which I
now.
think is great. I mean, I wish we had more housing clinics like that.
It is and we get folks who are, many folks come in who are not victims of some sort of violent crime, and so we send them as best we can to the resources, but it is definitely, we're a 3-person team doing the housing clinics, and it's definitely, we're trying to get more, because there's a lot of folks who come in and need that assistance.
Yeah.
So.
You do a fantastic job. I feel like I've worked with a raft of clients recently that are coming to us saying, I'm already getting help from the Sojourner House.
Yeah.
My landlord just needs to submit this or that.
Yeah.
And that's often what it is too. It's like a compliance issue. It's a two-way street, and what we want to avoid is a situation where a landlord can just run out the clock on a situation like that and ignore what needs to happen to keep a tenant housed, and then come to court and say, well, they haven't cooperated, they haven't paid, they haven't done whatever. It's not that simple, right? Because the landlord has to do their part too, even if it's just filing paperwork.
for, in a situation, particularly when it deals with evictions, with the recent eviction ceiling legislation that addresses what feels to be like 1% of the issue. And I don't know if you were there, Katie, for the workshop.
Yes, it was Dave and I, Brian presented
Our
with
colleague Brian.
with Jennifer Wood.
So one thing that I really got upset about and stuck on was what I really felt to be what I now know is something that was not even taken into account for by the state senate and their chief legal counsel, which was the idea of using your free eviction seal if there was a mistake made by the landlord, and let's say, you're staying at a place and, you're not on the lease and they put your name by accident and it's an honest mistake. What legal protection, if any, outside of advocating for legislation to ensure that tenants don't bear the responsibility of a mistake by a landlord that will leave them vulnerable to all the things that we know evictions lead people to?
That's a great question, and I guess I should start by giving you a disclaimer, which is, so one of the limitations we have at Rills is we, subject to some details, right? We can't get involved in lobbying and advocating for statutory changes. Subject to, there are some exceptions to that. So I hear you on the 1% of the issue. But I guess I would answer it this way. Until the statute is amended, which presumably there are enough people out there who feel like you do, that may happen someday, but I won't speak to that. I think a tenant can do what tenants have done before this law, which is to say, you've got some explaining to do. And you would have to explain, if the landlord says, well, I see this eviction here, you've got to explain, well, you know what, that's actually a mistake. And I realize that's cold comfort. It's not the best answer in the world, but I think that's kind of the state of play right now.
I think that's where we are. And to Steve's point, I think as a practice point, one of the things that myself and my colleagues try and do for the tenants that we help is, if there is really any outcome, right, that we help shape with our tenant, but if it's a beneficial outcome to them in terms of the case, if the case is gonna get dismissed, if there's gonna be a stipulation that lets them stay as long as they pay X amount or change their behavior in some kind of way, we want control as much as we can over the document that gets signed by the tenant and entered by the court, so that you can equip the tenant with that document. You can send them home from court that day with some kind of explanation, signed by the judge, of what happened and why. Because as Steve alluded to at the beginning of our remarks, the way the portal is set up right now, it's kind of the worst of both worlds for a tenant. Because the thing that triggers their presence on the portal is out of their control. It's whether or not the landlord files a lawsuit against them. That's what puts them on the portal. And then, no matter what, no matter how the case is resolved, they stay on the portal, but the resolution isn't visible to most people. So everything from like a trial that goes against the tenant and an execution to a landlord just looking on the portal, that's no different than a case that gets dismissed because, Steve and Kate help you at court and outfox the other lawyer. There's no difference right now. If the tenant's equipped with something from us and the court that says, here's what happened, we feel like that can be helpful to them.
And have there been ways in the past in which, without the eviction ceiling law being passed, that you could remove yourself, or maybe not the tenant could remove themselves, but through the court process, could they have themselves removed in certain situations?
So the thing I can speak to on that is a dismissal stipulation. If you bring me to court on a non-payment issue, right? And I've fallen behind, I acknowledge that, we agree on how much I owe, we're often able to work out some kind of agreement that says, you get a judgment today, signed by the court, but if I, make payments and pay off my balance by April 1st, the case will be dismissed. What we try and do when we can is follow up on that case so that when April 1st runs around and I've filled my end of the bargain, we can file one more piece of paper with the court that says the parties have complied with the terms of the stipulation, the case is hereby dismissed. At least that's kind of a receipt for the tenant to show whoever's interested, hey, I had a hiccup here and here's how it went.
Yeah.
Here's how it got rectified.
Just to finish the thought, other things that you might see that we do when it's appropriate is in a situation like that, we might add language that says, this is a settlement, it's not an eviction, and, both parties are waiving their claims, and, making clear to the non-lawyer reader who's gonna be reading it when they're deciding, do I want to rent an apartment to this person or not? Making clear that it's a settlement, right? Not an eviction. And again, though, it leaves the tenant in the position of, you've got some explaining to do, which isn't, which is an extra step that may make it hard on some people. So,
Yeah, I was just gonna ask why the resolutions or whatever are not visible on the portal.
So, I don't know why the portal operates this way, but the rule is that only attorneys can actually look at the filed documents. So you could log on to the portal and see, oh, there was a case against so-and-so, and read the titles of the documents that are filed. But unless you're given access by the court, you can't get into the document. And I don't know.
It's a balance. I mean, it's not my idea, but I think it's a balance between the public's right to know
Sure.
and confidentiality concerns that govern some court proceedings too. So,
Sure.
I think you can tell it's not quite the way we draw it up, but it's the way it is.
Yeah.
And we try and work
Even though it
within
says
that.
public.
Yeah, we try and work within that framework for sure.
But the irony is, this is a situation where most people would probably be better off if it wasn't confidential, right? Confidentiality is supposed to protect,
Yep.
like, for
Yep.
example, the tenant,
Yeah.
right?
Yep.
But like, you're showing enough bad stuff that the confidentiality isn't necessarily helping.
Yeah.
So.
It seems silly.
Kate, did you have a question?
I had a few questions. I think so the first one was like going back to some of the updates on legislation that passed last year with the application fees. One of the challenges with the way the legislation is written is the enforcement doesn't seem super clear. So when somebody, and we get calls on occasion, a lot of times, and this like goes into my second question, but somebody saying like, I'm being evicted or I got a termination of tenancy. But if somebody presents and there's like, my landlord's trying to charge me $75 for an application fee, what's my recourse? We've been telling them to contact the Attorney General.
Yeah.
Is that
That's what I would say too.
Yeah.
Yeah.
Okay. And just trying to document,
But I think, the one other thing they could do, because this is a new law,
yeah.
because a lot of people may not necessarily know about it, is just say, hey, you may not have heard, you can't do this anymore. Go look at 34/18/59, and hopefully that would help. But in addition to that, or if that doesn't end the issue and it's not just a good faith mistake, then I would let the Attorney General know, because I think they would probably want to know if that's happening, especially with bigger landlords.
Yeah. So that was question one. My second question was just if you, and I know I had to step out a couple of times, but we get calls from folks, and we're not a direct service provider, and typically, like, we refer them to you all, for Center for Justice. We tell them if you're at the courthouse, there's an eviction help desk, but I guess if you could, I think it would be helpful if you could, like, just kind of walk through the steps that you want somebody in our position who's, like, they're interacting with somebody, potentially it's their first time outreaching, when they've gotten either a 5-day notice or they've gotten a court document. You have posed some questions you thought were useful for us to ask earlier, but I'm just thinking it might be helpful to, like, go through that. And then how we would, like, make the referral. Makes sense?
Well, I think it's always good to figure out as early as you can where they are in the legal process.
Yeah.
It could be a problem that hasn't manifested itself that way yet. I give our clients a lot of credit. The vast majority of them that I work with are hyper literate and hyper aware about their own situation. They're very rarely blindsided by something that's going on. If you ask them, it might take a couple questions, but they'll tell you, this has been brewing for a while, I did this, he did that, they can tell you. So it's always good to ask and get a sense of where things are in the process. And if they tell you, hey, I got a court notice for this date, that clarifies a lot. But if they're telling you, he sent me an angry text message, or he's just knocking at my door saying this and that, that's helpful information, but that's different. That's not a legal problem necessarily. The other thing, it's a question we often ask and have to figure out, but the documentation that the tenant has of what's going on is often very important. We talk about the power imbalance at court. I think another manifestation of that is clients don't often think that it matters that they really put in writing what's going on with the landlord. It doesn't have to be a mimeographed letter, right? It's a text message, it's email, it's receipts on, Venmo, PayPal, all this kind of stuff that can be very important when a case gets to court. But I think having a general sense of where a case is in that pipeline and what it's about, like I talked at the very beginning about, a lot of cases are about money, it's a non-pay case. A lot of cases are about the termination of tenancy. A tell there is the letter that they get won't specify an amount of rent. It won't say you're in arrears, you owe this much. Some kinds of termination cases are about specific behavior, and you'll know that from what the tenant gets too, because it will, or should, list out the specific behaviors that they've been engaging in that aren't gonna fly. So anything basic that helps us kind of define the case like that, super helpful.
Let me try and break it down into some pillars, because what you want to figure out is, first, is it pre-case filing or post-case filing? Are we just at the notice stage, or has a case been filed? If a case has been filed, next question is, are we pre-judgment or post-judgment? And if we're post-judgment, then the last thing you need to know is, has there been an execution issued? And so, an execution is, we talk about these cases as like, oh, it's an eviction. That's kind of true, kind of not true. The actual eviction, the move out, the forced move out, happens when the court issues an execution. That comes at the end of the eviction case, and that's when they can say to you, all right, you got 48 hours and we're going to move your stuff, right? That's the actual eviction. So are we pre-court, post-court, or pre-filing, post-filing, pre-judgment, post-judgment, pre-execution, post-execution? And what I would say is, so you can always tell people to call, our number and say you have a housing problem. I mean, I think we're pretty good about getting back to people. Sometimes there's phone tag involved. But if it's urgent, if you're post-judgment, post-execution, or like somebody got a 48-hour notice on their door, feel free to send them to our offices to come down and do an immediate intake. We can do that now, now that we're sort of post-COVID, right? We're all back in the office. Or the help desk, we're there, but again, the sooner they come, the better.
So Steve, I don't want to interrupt you, but Steve hit on a great point, which I sometimes remember to actually say myself, but why? The bedrock piece of advice that you may have already given to tenants, but if you don't take anything else from this, it's that only a court can evict a tenant.
Yeah.
Right? A landlord can't do it on their own. It's not legal. And when you hear Steve talk about execution, that's what gives the landlord the court's permission. Right? So that's one of the fulcrums of these cases, because up until the execution, the tenant still has some legal protections. And the court's permission, the execution, that's what kind of shifts the balance even more.
Yeah. We do have an FAQ that like goes into this. I think we worked with you all on it.
Yeah.
Maybe it would be great to look at it again, and it probably needs to be updated. So that's like a helpful guide. Do you have anywhere like samples of the different types of notices that people might receive? Because I think that's helpful too, to just like put out there, like if you got this, like this means this. If you got this, this means this. So like people, I know what you mean about people knowing where they are in the process and they know what's happening to them a lot of the times, or they can describe it and you can kind of, you can find stuff out by asking questions.
That's what it takes, because if someone comes to you and says my landlord's trying to evict me, that encompasses quite a bit.
Yeah. So, but I think having some of those like to just guide even for folks working in the space who might not have seen those, that would be helpful.
That might be a good thing to add to the FAQs.
Yeah.
I will say the notices, sample notices are included in the back of the statute. What are that?
I'll send it to you, because I'll just pull them off and send them.
Okay.
Yeah, but then the question is, okay, great, what does this mean? So that's the kind of,
Yeah.
we can do that in the FAQs. I think that'd be a useful thing to.
Yeah. There's
to
a
add.
lot of, I would say, we get people, I think, at all stages of the process, but a lot of them are, I think, we get a lot of pre-filing, like I would say, folks, and then like pre-judgment, like they haven't been to court yet, but they know, they've gotten a notice. But I guess what I'm hearing is like ask questions, and then the earlier there can be some type of legal intervention as appropriate, the better. So that is what we try to do.
Yeah, and then just one last sort of detail on the process. I don't exactly know what the numbers are as I sit here today, but I think historically, the default rate, and I'll explain it a little more, in Rhode Island is about 22%. And when I say default rate, I mean the number or percentage of people who have an eviction court date and don't show. So what happens is you get a judgment entered against you, and then sometimes we can peel that back, but it becomes more of an uphill battle. So I think just another thing to keep in mind, another thing to ask is, do you have a court date? Because if they have a court date, you gotta show. Otherwise, you're really not helping yourself. So, and unfortunately, about 22% of the people who have court dates for this don't show.
And just to that point, it really is kind of an own goal when that happens, because since so many of these cases are settled, you know, and the expectation by a lot of landlords is we'll file this to get their attention, but then we settle. If a tenant doesn't show up in court, you're really oftentimes giving the landlord more than they're even expecting or asking for by gift wrapping a judgment for them that they, you know, maybe could have been avoided.
Any other questions?
I have another question, but I feel like I don't wanna, I know we're at time, so I wanna be respectful.
It's all right.
We get a lot of questions around code enforcement, right? Like, so I'm just wondering how legal service provider, how you interact maybe with code enforcement, if you
That's a great
do,
question.
or how we might, if a tenant is, presenting and saying like, this has been an issue, trying to ask questions, understand what the situation is, if the tenants actually reported it, or if it's just been a complaint they've had with their landlord and they've been kind of going back and forth on it, and how things can escalate, into potentially, court intervention, right? Like, so I guess I'm just wondering, like, how do you I don't know that my question's clear, just how do you interact with it, and what are some ways we can try to guide tenants in that situation? That's more it might not be more specific, but it's less straightforward than like, you didn't pay your rent, you're late.
Let me
they're asking
take
you
a
to
stab,
leave.
and then you can chime in.
Oh.
And you can tell me if
Steve's been very proactive in
It-
trying to figure this out.
if I'm not answering
Yeah.
what you think the question is,
Yeah.
just let me know. I guess I'd start with some of the town code enforcement folks are more proactive and open to our clients than others are. So it kind of depends how we interact, what we're able to accomplish, may sometimes depend on where we're talking about. But what we do is, in the appropriate case, we try and get code involved. I can tell you that whether it's the official line or unofficial line, in my experience, tenants are better off getting code involved if they have real conditions issues before the landlord files eviction, because sometimes I think if you wait until after the landlord files an eviction, code officers are just like everybody else. They're overworked, have a big stack of things they need to deal with. And I think that there's a tendency to look at ones that only come in after an eviction is filed as less meritorious than other ones that come in earlier before an eviction is filed, rightly or wrongly, so if there are real conditions issues, I always say the first thing they should try and do is work it out with their landlord. There's no substitute, never will be a substitute for communication. And we are always happy to help on that front. That's frankly one of the big roles that we can fill. But if that's broken down and people have tried, then I think you wanna get code involved, sooner rather than later. Now, sometimes, if the conditions in the apartment are so bad, that can, I'm gonna say, backfire in the sense that the place may get condemned. Which is never a great outcome, on the one hand. On the other hand, if it's that bad, then even though it's tough medicine, you probably shouldn't be there anyway. But that's kind of an unsatisfying situation for somebody who has nowhere else to go. So anyway, those are some of the things we think about. And I do think that code, as a general matter, code is becoming a more willing participant when we have cases. But there's no question that if it comes in after an eviction, people kind of look at it, with the side eye.
That includes the court. The timing of when code gets involved versus when a lawsuit gets started is sometimes very important factually in court, because there's a presumption of retaliation. If code is involved in February and the eviction notice and lawsuit comes in March, the landlord has to rebut the presumption that that's a retaliatory act. Steve alluded to this too, and it comes up a lot once cases get to court. I think tenants they've got more protections than they did a year ago when it comes to how and when not to pay the rent or where to pay the rent.
Yeah.
Instead of to your landlord, the Attorney General's office has, just within the last legislative session, they spearheaded 2 or 3 different bills that allow tenants to, instead of paying their landlord rent, they put it in a court escrow. And it gives them, I think, more grounds to withhold rent when there are lead certificate concerns. I don't mean to gloss over that, but those are 2 kind of important new laws that tenants can avail themselves of with our help if they need it. We often hear from tenants that will say, I owe my landlord rent. The conditions are also horrible. That doesn't necessarily turn into a valid legal defense. They have to do a couple things right, and importantly, they have to show the court that they have the money that's ready to pay. I don't want to get too in the weeds of it, but it's a place where the frustration that tenants undoubtedly feel about living in the conditions they're living in and having the resource scarcity that they have runs into the rigidity of what the legal defense actually is.
Yeah.
So what they're living through practically isn't the same as what they have to do legally.
But just to give you some practical pieces of information that really came to me now that I think go to your question. The things that tenants can do to help themselves with that legal defense. Take pictures, have the proof, keep the text messages where you're saying to the landlord, this is a problem, right?
Yeah.
If you have it in writing and then there's a case filed, you have your presumption, right? If you have the pictures and they look really bad, you are much more likely to get a judge's attention. And it won't mean that it justifies you paying 0 rent, for the last 6 months, but it may well mean that, your rent is reduced 30%. Just pick a number by way of example. So those are things that we tell people, take pictures, save your text messages, and that sort of thing.
My last question is, just because when I'm in housing clinic talking to people, and many of them are looking for some sort of representation, but they're, like you said, they're scared because it's a big, daunting, scary thing, and so I try to give them as much information as possible. But if you could speak to literally what happens after they call or do the online form or whatever, like what happens step by step, so I could tell somebody this is what you can expect to do to get some of that assistance.
Great question. You wanna handle
Yeah,
this
yeah,
one?
So, they call our office, they do, they ask to be connected to the housing department, they kinda do like a pre-screen on the phone, and then it gets sent to our, legal assistants, and they have a callback list, and that's what they do all day long, is return all the calls, screen them over the phone, do the intake over the phone, and every Tuesday and Thursday, we have advice and counsel, so whether they have a court hearing, they get assigned to an attorney to return the call for either advice or potentially represent them in court. And if it's something that's an emergency, that, you know, it's an emergency, they get called back ASAP.
Yeah. And so, just to give you a little bit more detail, in that intake process when they talk to someone, obviously, you know, because we represent people for free, we have income caps and asset caps, to determine, you know, is this someone who can access the private bar or needs free help? And then the other thing that, two other things that we will look at are, you know, do we somehow have a conflict? And the way that conflicts may arise, could be, well, oh, you know, this person's complaining about their neighbor, but oops, we represent the neighbor. You know what I mean? Just as an example. We also do foreclosure defense. So occasionally there are situations where we may represent the landlord / owner of the house in a foreclosure action that might give rise to a conflict if the tenant calls and says, you know, my landlord's trying to evict me. So we look at conflicts, and then the other thing is, we ask ourselves, is this a legal problem that we can help with? If they're calling about an eviction, the answer to that is gonna be yes. But just, you know, to kind of give you a sense of the things that we run through. And if for some reason we can't help, we always refer Center for Justice, Volunteer Lawyer Program, and we have some other resources too that we can refer to.
And no matter when they call, there's always something we can do, whether it's refer them out or help them out. There's never, we can't help you, I'm sorry.
Yeah.
There's always something that we can do.
Awesome.
Yeah.
And part of why we like to do these events is so we can be available to you as advocates as well, because we don't want
Yeah.
everybody you deal with to be at the mercy of the intake process.
And we've
If
gotten
there's
that
something we
before,
can help
like,
you via
right.
email or something.
Yeah.
Yeah, so
Sure.
Yeah.
they have, or my card or whatever, they, and I can do the intake over the phone,
Okay.
that way too, so I've done that. Or if we're at the courthouse, they're more than welcome to come down and, can do an intake if we're down there. But, yeah, we've done that, like, if you called and say, hey, I've had a client tried to reach out and we haven't gotten, you know,
Mhm.
Sure.
give them my extension or whatever, but.
Yeah, and that's the thing too, you know, like one of the great things about having the resources to be able to go out and really not like double down, but triple down on the kinds of outreaches we do is, we've met people like you know, and we've learned about what you're doing. We share about what we're doing. And I'm a huge believer in, if we all help each other, we can do so much more. And so for us to be able to do that, we have to know what's going on and who's doing what. And we've really been able to learn so much more about all the good work that's happening out there. And it's improved our results because, again, it goes back to, yeah, like an eviction case is a legal problem, but there's so much more to it, right? There's the root cause of the housing instability. There's the other supportive services that almost all of our clients need in one form or another, right? And so now, because we've been able to really take a crash course in what's going on around the state, we've been able to link people up with other services they need.
Yeah.
But I want you guys to know that, you know, hey, we're part of that universe. So don't be shy about linking people up with us,
Sure.
because that's what it's all about,
Mhm.
you know?
And I really appreciate that, because I think that the stigma, I think, with lawyers and then the court and whatever, it's like, it's this big daunting, scary thing that isn't accessible, but like, being trauma informed on every level and acknowledging that like, all these people have so many co-occurring things that are happening
Mhm.
Yeah,
that
this
are
is
the
just-
result of their housing, or
Right.
like, the housing is a result of that piece.
Yep.
It's like, yeah, I appreciate that perspective, because I think that makes those connections happen better and serves the people who need the most help in the best way, so.
Yeah.
For sure.
So it's funny that you're bringing up, particularly when it comes to like lead and the legislation that was passed last year, and the more rights that tenants have when it comes to choosing to withhold rent or whatnot, because one of my, like, that situation had happened to me and my family about a decade ago. We were renting out to landlords who basically they just refused to deal with toxic mold, black mold, and elevated lead levels. And we were living, it was me, my two brothers, my mother, and my grandmother, and my little brother at the time, who might have been no older than maybe 4 or 5, had gotten asthma. My mom had done all the right things, took the photos, saved the text messages. She still has them today. But when it came to reaching out legally at the time, and this might have been like 2014, 2015, around that time, every lawyer she reached out to was like, because the people who owned the building was the Greek church in Cranston. And the Greek church has a lot of connections within the city of Cranston at a political level. And so nobody wanted to touch it, essentially. And so hearing it kind of brought up, oh, well, this would have helped our situation at the time. I guess my question was, and I wasn't planning to ask it, but is there anything, because I'm pretty sure they're still not lead certified, and there are tenants now living in that. Is there anything that we can do to ensure that what happened to us doesn't happen to whoever's living there, or does it exceed the, I guess the statute of limitations in terms of what tenants or former tenants have?
So, good question. I don't know what the statute of limitations would be offhand on a personal injury claim, for example. One of the good things about bringing me in is before I came to Rhode Island 5.5 years ago, I was in New York for 20 years. So I don't know anybody. I've never been to the Greek church. But what can you do now? I mean, I think there is a database that will show, does this address in this town have a lead certificate?
And that's what I looked
Yeah,
up.
yeah. Because you don't live there anymore, right? It wouldn't be your case, right? But I think that someone could call code. Someone could call the Attorney General's office. And put that on people's radar. And I have to say, I mean, I think, I wasn't here in 2014. I don't know what the attitude was with respect to lead, but I can say this, that in the last several years, thanks to the Attorney General's office and others, the Childhood Lead Action Project, the attitude around the dangers of lead has really changed. So whereas, 10 years ago, you might have gotten crickets. I actually don't think you'd get that now. And so I think it's a different world with respect to lead, which is the good news.
Thank you.
Is there information, so like you have resources available, CFJ, other like advocates, we put out some stuff. Is there, and the AG's office too, of course, is there information that you think like specifically and globally is helpful for advocates, or like, I think Holmes or I were in a position, right, where part of our role is information sharing, and so is there information that you wish more tenants had that, I mean, not that we would reach everybody, but just in terms of producing materials and just keep repeating something that you wish people had before they got to you or would be helpful about the process?
Maybe Kate can address, the way we all know Kate is because when rent relief was
Yeah.
around and all that,
Yeah.
like, all roads led to that in terms of
Yeah.
like an information center.
Yeah.
I think it's more difficult now
Yeah,
to send people to one place.
Yeah. yeah, I go by the last number of your zip code to find resources for people, So I wish there was something that, and everything changes every day. I log on to like either the Projo or,
Yeah.
the coalition, just to see what has changed, what has been added, word of mouth,
Yeah, everything does change. We sort of took a stab
yeah,
at getting resources in people's hands with this brochure. It's, QR code based. So there's a lot in here. And so, like, for example, with the lead, with the website, that'll tell you, is there a certificate on file? You can get to that through here, for example.
it's like back to work RI stuff for like employment,
Yeah.
like the state will
like
post all the,
Yeah.
that has all that, a lot of the resources that I use went on there, like, SNAP applications,
I think I guess what I'm hearing is, my question was more like to be more direct, I think, is like, what do you think we could do to, I'm just thinking about ways that we could like help share information. But what I'm also hearing is that there's not exactly a centralized place for tenants and landlords to get information. I mean, they can read it if they go to the handbook and like the law and see, but something that was more, like organized.
With respect to
accessible.
With respect to resources, you're absolutely right, which is why Katie's involvement is so
Yeah.
critical to us, right? Because she is the closest thing I'm aware of to a resource clearinghouse. I don't think of you
Yeah.
that way, but
yeah.
that's it for us. And there
I
are
mean,
other
just
good.
being in the field for so long,
Yeah.
like, I know so and so at so and so that can
Yeah.
do this, and she did this, and kind of picking brains everywhere and doing events like this, like,
Yeah.
you may know something that I don't, and but basically to get to us, it's like knowing that we talk about signs of instability, and that's like the biggest thing. And when clients walk away with me, it's like they come like, all right,
I don't mean to put Katie on the spot, but like the amount of information she has without even knowing and can access based on if school-age children are involved,
right.
or
Yeah.
if there was a domestic violence incident involved.
And that's just by active listening, like, oh, your child's at the
Yeah.
training school because
Yeah.
he did X, Y, and Z, well, you must have DCIF involvement,
And-
or FCCP's involved because you have blah, 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 and so it's
Yeah.
getting those releases signed and working with them, and
And the difficulty you're getting at is that all these cases are they become fact specific at a certain point.
Yeah.
So there's no one central repository. If you're thinking about information that you want to put out there in a general sense, I'd say that it's only the court can evict you. Your landlord cannot do that on their own. They have to follow the process. And beyond that, if they have questions, like, we're willing to help.
Yeah. But I'll leave these here. I mean, I actually think this is a helpful, it's a good
tool,
one
and
because
then
there's a lot
I'll
of
obviously
resources.
leave my cards that you can, because I think to get to me first is better than getting to
Oh, yeah.
Dave, because that means,
Yeah.
uh-oh.
Well, the good news is, after doing about half a dozen of these with Kate, I finally brought my own cards.
Yes.
So it takes me that long to learn, but here they are.
But
So-
out of like, you know,
Yeah.
almost 100 cases that I've been working with, I've not one person has the same plan.
It's true.
So that's how, it's like, they're not just, it's really individualized and they appreciate it. We went to I don't know if you went to the training last week at the Shepherd Building, the Department of Housing, and
The mini conference.
Yeah,
Yes.
yeah.
and how the three ladies that were on the stage, and like, I wish we had someone to work, now we're housed,
Yeah.
now what? You know, and
Yeah.
that's, I'm the
Yeah.
now what, like, all right, you're
Mhm.
housed now, and like, this is National Grid, and you can get on a budget plan right now, do it right now, before you know what I mean, fall behind, or you live in this neighborhood, they do dinner every week, they do food baskets every Saturday, just those services to help them, cause they're embarrassed to ask, or, you know,
Yeah.
I just want to say thank you guys for the work
Yeah.
that you do, because we do get a lot of phone calls from people that are either facing eviction or going through the process, or you know, even that are currently experiencing homelessness. So to have a resource that we can actually send people to and feel like this isn't, like, you know, people come to us and the biggest frustration they express is like, I've reached out to so many people, I've
Yes.
called,
You're the only one who's answered
they
the
go
phone.
down
We
the
get that a
list,
lot,
and it's
yeah.
like they're just grateful to
Yes.
speak to someone, to have someone listen,
Yeah.
but you don't want to feel like you're just lobbying, like, you know,
Right.
volleying people to different organizations and saying like, well, hope they can help, we can't. So
Right.
to, you know, for you to say that even if you can't directly provide services, that
There's
you
someone I
have
can-
information
yes,
that you can hook
for
them
sure.
up with someone. So
Yep.
it's nice to know, you know, like, people will come to us through United Way and they're looking for rent relief, and it's really hard to say like, well, there's no funding for that right now, we don't have that, so, you know,
And I'll
the
say,
response
like,
isn't
right.
like, sorry, we can't help.
I'll say try X, Y, and Z. And
Right.
if that doesn't work, call me back.
Mhm.
And I'll say, all right, that didn't work, try A, B, and C. The funny thing with United Way, it was back when rent relief was like hot back in, when I was at 2021 or something. I remember calling United Way when I was working at Crossroads and, looking for something, and they gave me my desk number. I'm like, that's my own number.
Right, right.
I started writing down. I'm like, this looks familiar to me.
You
So
have all the answers with
I thought it was
Right.
funny because that was like, you know, there was so much money back then that the people were just, and it was, I'm like, that number looks familiar to my desk.
Oh, that's sweet.
Well, we're so happy that we could do this, and you know, I appreciate the comment.
Yeah.
And you know, we can keep doing these if you want to do it once a quarter, or whatever you think is would be helpful.
We
So,
had an idea, so I'll talk to you after.
all right, sounds good.
Thank you so much.
Thank you guys.
Really
Thanks for
nice
having
Thank
us.
you.
Thank you.
Come take some stuff, pens and
Yeah, I'm gonna leave these here.
cards and.